The Valley Current.
Welcome to the Deep Dive. Back in 1962, if you filed a federal civil lawsuit in the U.S., there was actually an 11.5% chance that your case would end up in front of a jury or a judge.
Yeah, better than 1 in 10, which honestly sounds pretty reasonable.
Right. But today, that number has plummeted to roughly 0.4%.
It's a staggering drop.
It really is. I mean, out of over 374,000 pending civil cases, maybe 1,500 will actually see a trial. So for you listening, whether you're an entrepreneur trying to scale your business, a corporate leader managing risk, or just someone who's, fascinated by the hidden architecture of these high-stakes systems, it raises a massive question.
Right. If nobody is actually trying cases anymore, what exactly are armies of the most highly educated, highly paid professionals in the country actually doing?
Exactly. Like, what are they doing for the 35.6 months it takes, on average, for a case to work its way through the system?
Well, they're locked in a procedural war of attrition. Yeah, the litigation process itself has basically become the actual battleground. So instead of arguing over the substance of, say, a breach of contract or the theft of a trade secret, the attorneys are spending those 35 months litigating the rules of engagement.
So they're just fighting over how to fight.
Exactly. They fight over who has to produce which internal emails, how broad a keyword search should be, or, who is allowed to be deposed and on what date. It's endless.
And that brings us to what we're exploring today, this sort of hidden civility economy of the American legal system. We're pulling from an incredibly detailed briefing authored by Jack Russo from Computer Law Group, LLP, dated today, actually, July 13th, 2026.
It's a fascinating read.
It is. The briefing is titled, Does Civility Enforcement via Sanctions Cause More Incivility? And our mission for this deep dive is really to figure out if punishing lawyers for bad behavior actually deters that behavior, or if the system is inadvertently engineering this permanent spiral of retaliation.
Because when the system breaks down into that procedural war of attrition we just talked about, It's the client, like the founder listening right now, who ultimately absorbs the catastrophic costs in both time and focus.
Right. They're the ones paying the bill for the 35-month wait time.
Exactly. That average wait time is just a perfect metric for systemic dysfunction. The briefing actually applies game theory and institutional analysis to look past the symptom of those high costs, and it diagnoses the structural disease in how we litigate.
And it all starts with the foundational DNA of the civil justice system, right? Federal Rule of Civil Procedure 1.
Yes, FRCP 1.
Let's dig into the actual text of this rule, because it serves as the mission statement for the entire federal civil system. So the rule dictates that all the subsequent procedures should be construed and administered to secure the just, speedy, and inexpensive determination of every action.
Just, speedy, and inexpensive.
I mean, if you put that on a corporate brochure, investors would love it.
Oh, absolutely. And it was genuinely designed to be this ultimate guiding star. In fact, back in 2015, the Rules Committee amended Rule 1 to explicitly state that both the court and the parties have an affirmative duty to employ the rules to achieve that goal.
Right.
Chief Justice John Roberts even issued a major year-end report urging judges to take a stewardship role. The mandate was super clear. Judges should actively manage cases from the outset rather than just sitting back and letting the adversarial parties dictate the pace.
Right. The expectation was this big cultural shift toward efficiency. But the briefing identifies a fatal structural flaw in that mission statement.
Yeah, a massive flaw.
It is a command without a consequence. Like the advisory committee's own notes from that 2015 amendment explicitly admit that Rule 1 does not create a new or independent source of sanctions.
Right.
So you can completely ignore the mandate to be speedy and inexpensive, and you cannot be punished for violating Rule 1 on its own.
It's entirely toothless. And if we look at this through the lens of institutional incentives, a toothless rule in a high-stakes environment is arguably worse than no rule at all.
How so?
Well, imagine two massive, well-funded corporations squaring off over a patent dispute worth like hundreds of millions of dollars. The system politely asks their counsel to be fast and cheap.
Right.
But it threatens absolutely zero penalty if they are slow and staggeringly expensive. In that scenario, delay and expense aren't just unfortunate side effects anymore. They become rational, weaponized strategic tactics to drain the opponent's resources.
It's like, okay, imagine building a massive 10-lane highway and putting up this beautiful digital billboard that says, drive safely and courteously.
I love this analogy.
But then you explicitly announce that there are no police on this highway, no speed cameras, no highway patrol.
Just the sign.
Just the sign. And instead of policing the road, the government just hands every single driver heavily armored bumper cars and says, look, we can't pull anyone over for driving aggressively, but if you think the person in the next lane is a menace, feel free to smash into them and teach them a lesson yourself.
That is exactly it. It's a remarkably accurate visualization of what the briefing refers to as the weapons bazaar of civil litigation. Because the system can't enforce that overarching philosophical mandate of Rule 1, it just relies on this fragmented collection of blunt, specific instruments to police civility and cooperation.
So let's break down this arsenal. Because if this is what lawyers are using to smash into each other for 3 years, we need to understand the weapons. The briefing highlights a few heavy hitters, starting with Rule 11.
Right. Rule 11 is arguably the most famous one. It covers improperly grounded filings. So essentially, when a lawyer signs a pleading or a motion, they are certifying to the court that to the best of their knowledge formed after an inquiry reasonable under the circumstances, the document is not being presented for any improper purpose.
Like to harass or cause unnecessary delay.
Exactly. It also certifies that the legal contentions are actually warranted by existing law, and that the factual contentions have evidentiary support.
So if you file something entirely frivolous, just completely made up, the other side can hit you with a Rule 11 sanction.
Yes, but that's just the paperwork side.
Right. So what about the actual behavior during the case?
That brings in Section 1927 of the U.S. Code. This statute allows a court to penalize any attorney who so multiplies the proceedings in any case unreasonably and vexatiously.
Unreasonably and vexatiously.
Yeah, so if a lawyer drags out a simple dispute by filing endless redundant motions or taking completely unreasonable positions that just force the other side into a labyrinth of busy work, they can actually be forced to personally satisfy the excess costs and attorney's fees caused by that conduct.
Personally. Wow. Okay, then there was Rule 26G, which the briefing spends a lot of time on regarding discovery. And discovery is that phase where the parties demand documents and emails from each other, which really seems to be where most of the money is burned.
Oh, without a doubt. Discovery is the furnace. And Rule 26G is the mechanism designed to police that exact burn rate. It requires lawyers to sign every single discovery request, response, or objection. And by signing, the lawyer certifies that the request isn't unreasonable or unduly burdensome, given the needs of the case, the amount of controversy, and the importance of the issues.
Which is just an incredibly subjective standard. I mean, what I consider a proportional demand for your company's internal emails, you might consider an extortionate attempt to shut down your servers entirely.
Exactly. And that subjectivity is the fatal flaw in the weapons bazaar, which history has already proven, by the way.
The 1983 amendment.
Yeah, the briefing dives into this historical precedent of the 1983 amendment to Rule 11. Basically, the Rules Committee realized things were getting out of hand, so they made a seemingly logical choice. They made sanctions mandatory.
Mandatory sanctions.
Right. If a judge found that a lawyer filed something improperly grounded, they had to impose a sanction. The theory was that strict, unavoidable punishment would force attorneys to self-police and just stop filing frivolous motions.
But history shows through mandatory punishment backfires spectacularly. Instead of attorneys suddenly becoming polite and cautious, they turned the punishment mechanism itself into the primary weapon.
It was a disaster. It spawned this era of what legal scholars call satellite litigation. Lawyers realized that a mandatory Rule 11 sanction was a devastating tool. So if opposing counsel filed a motion to dismiss my case, my strategic priority completely shifted.
You wouldn't just argue against it.
No, instead of just writing a brief arguing why their motion was legally wrong on the merits, I would file a separate Rule 11 motion demanding they be sanctioned for even attempting to dismiss my case.
And then the opposing counsel wouldn't just defend their original motion, right? They would file a cross motion for sanctions, arguing that your motion for sanctions was in itself a frivolous, sanctionable offense.
Yes. Professor Georgine Viro is actually quoted in the briefing describing this perfectly. She said, one side would move to sanction his opponent who might respond in kind by filing a sanctions motion on the basis that the filing of the original sanctions motion was itself sanctionable, and on and on.
And on and on. So the underlying lawsuit, like the actual reason the clients were paying these lawyers in the first place, just became an afterthought.
Completely. The courts were completely bogged down adjudicating attorneys suing each other over the way they were suing each other.
That's insane.
The 1983 experiment definitively proved that lowering the threshold for punishment doesn't create civility at all. It creates a recursive loop of hostility. The rulemakers eventually had to surrender. They walked the rule back in 1993 to make sanctions discretionary again, and they added this 21-day safe harbor provision, giving lawyers a chance to withdraw an offending paper before a sanctions motion could even be filed.
But here's the thing. Even with that 1993 walkback, the fundamental architecture remains. We are still relying on this arsenal of highly subjective, blunt weapons. And this isn't just ancient history from the 1980s.
Not at all.
This exact cycle of punishment, creating more hostility, is happening right now, which brings us to a massive current clash over kombucha.
Yes, kombucha.
The briefing uses this anchor case study, Patel v. GT's Living Foods. And we're going to look very closely at a sanctions order issued on June 18, 2026, by Magistrate Judge Thomas S. Hickson in the Northern District of California.
And this case study is really the linchpin of the briefing's analysis. But before we explore it, we absolutely must establish very clear parameters for the listener.
Yes, the impartiality caveat.
Exactly. We are not examining this case to decide who the good guys or the bad guys are. We are looking at this dispute strictly through the lens of incentive structures, institutional design, and how capable lawyers navigate a deeply flawed system.
Right, we're looking at the machine, not the operators. Yeah. So the backdrop is this long-running, complex class action lawsuit over the labeling of GT's Living Foods kombucha products.
Okay.
The defense is GT's Living Foods, and they're represented by a massive, highly prestigious national law firm, Davis Wright Tremaine. Specifically, the briefing focuses on the actions of partner Jacob Harper and a former associate, Joseph L.M. Myers.
Yeah.
But the explosion we're looking at isn't a fight over the actual kombucha labels.
Right. It's a procedural fight.
Exactly. It's a fight over a subpoena issued to a non-party.
So what happened was the defense issued a subpoena to a law firm called Smith Cravoche. This firm had previously represented the plaintiffs, but had actually withdrawn from the case. The defense's strategic goal was to investigate whether these former lawyers were still secretly involved, maybe pulling the strings behind the scenes or directing the litigation from the shadows. To uncover this, they demanded documents and scheduled a deposition via the subpoena.
And the former lawyers pushed back hard. They argued they were completely removed from the case and that this subpoena was an incredibly burdensome, unnecessary fishing expedition.
Which is a common defense in these situations.
Right. And the dispute just spiraled. Immense amounts of time and money were burned. And while the subpoena was eventually withdrawn, the former lawyers pressed forward with a motion for sanctions against the Davis Wright Tremaine defense team. And Magistrate Judge Hickson granted those sanctions. When you read the breakdown of the judge's order in the briefing, the sheer number of technical procedural slip-ups involved in this single subpoena is staggering.
Yeah, the court concluded the defense knowingly issued a subpoena completely riddled with defects.
Let's unpack the specific defects the judge found, because they illustrate just how granular this warfare gets. So first, the defense failed to notify the opposing counsel that they were serving the subpoena on the third party. Rule 45 actually mandates that prior notice be given, so the opposing side has a chance to object before the documents are handed over.
And the real kicker here.
Yes. The briefing highlights that the text of the rule requiring this notice was literally printed on the face of the subpoena form the defense lawyers used and signed.
Ouch. Yeah, when the specific procedural requirement you violated is physically printed on the document bearing your signature. Arguing that the omission was a mere inadvertent mistake becomes nearly impossible in front of a federal judge.
And the errors just cascaded from there. They served the subpoena on a registered business agent instead of personally serving the individual attorney they actually wanted to depose.
Right, and personal service is a strict requirement for a reason. You are commanding someone to appear under penalty of law. You have to actually put the paper in their hands.
Exactly. Then the subpoena contained an ambiguous definition of who exactly the recipient was. And finally, they failed to include the required witness fees. That's the check you have to hand a witness to cover their travel and time when you demand their presence. It was just this chain reaction of unforced procedural errors.
Consequently, the judge sanctioned the defense lawyers. He ordered them to complete mandatory in-person continuing legal education CLE classes focused on federal court litigation and ethics.
Back to school.
Literally. He also invited the sanctioned parties to submit a bill for the attorney's fees they incurred fighting the subpoena, and the briefing notes that resulted in a fee request exceeding $100,000.
Over a single subpoena. And this is where the briefing delivers the absolute aha moment of the entire analysis. Jack Russo pulls the camera back to look at the broader ecosystem of these high-end litigators. Because just 6 months prior to this June 2026 sanctions order against the defense in the Patel case, that exact same defense lawyer, Jacob Harper, was sitting on the opposite side of the sanctions table in a totally different federal case down in the Central District of California.
That case was Golikov v. Walmart. And understanding Harper's role in Golikov is so essential to grasping the systemic paradox here. In that case, Harper was representing Walmart. The plaintiff's lawsuit had fundamentally collapsed because discovery revealed the plaintiff purchased the product online, which subjected her to a binding arbitration clause, rather than purchasing it in a physical store as initially claimed.
So the case should have been dead on arrival once that fact came out.
Logically, yes. However, Harper successfully argued to the court that the opposing counsel obstinately doubled down. He demonstrated that they refused to admit the fatal defect in their case, refused to dismiss the claims, and instead engaged in vexatious tactics that unreasonably multiplied the proceeding.
Here's that word again, vexatiously.
Exactly. Harper didn't just win the argument, he orchestrated a devastating punitive victory. He persuaded the judge to impose a massive $623,738.70 sanction against the opposing counsel for their bad faith continuation of the litigation.
Over $500,000. So a mere 6 months ago, this same attorney is the architect of a $500,000 punishment against another law firm for abusing the system.
Yes. And the critical detail is the identity of the law firm he sanctioned in Golikov. The firm ordered to pay that massive penalty was Dovell and Lunar.
And who is the current opposing counsel representing the plaintiffs in the Patel case sitting across the aisle while Harper himself is sanctioned for the defective subpoena?
It is Dovell and Lunar.
The exact same players. The punisher and the punished are swapping roles within a 6-month window. Jack Russo identifies this as the punisher's paradox. This revelation just shatters the narrative that civility enforcement is simply about courts policing isolated bad actors.
Completely shatters it.
Because within this microscopic ecosystem of high-end repeat player law firms, the same individuals wield the weapons of the bazaar one month and get struck by them the next. It reveals an ecosystem entirely captured by retaliation.
And this dynamic is precisely why we have to interject with that crucial impartiality caveat again, which the briefing carefully emphasizes. The sanctions order against Harper and Eli Myers in the Patel case is not the final word. It is currently under active, aggressive challenge. The defense lawyers have filed a motion for relief from the magistrate's order, and their counterarguments are robust and structurally significant.
Right. We have to lay out their defense because it perfectly illustrates why relying on a judge to play referee in these disputes is so fraught. The defense is essentially arguing that Judge Hickson's order rests on a clearly erroneous recitation of facts. They aren't just apologizing. They're telling the system it fundamentally misunderstood their actions.
They actually submitted sworn declarations directly contradicting the narrative of bad faith. For instance, the judge criticized them for not properly communicating during the meet and confer process. The defense provided evidence stating they did accurately, quote, deposition dates during those calls, and they did explicitly offer to narrow the scope of the subpoena to alleviate the burden on the former counsel.
And they made a brilliant point about the deadline.
Yes, the scheduling order.
Right. The judge heavily criticized them for refusing to move a compliance deadline for the subpoena. But the defense explained that in federal court, you are bound by the judge's overarching scheduling order. They argued they were legally blocked from altering that specific subpoena deadline because the plaintiffs control the overall discovery extensions in the case.
So if they unilaterally moved the subpoena date, they would have violated the court's overarching scheduling order.
Exactly. They were trapped between accommodating opposing counsel and obeying the court's strict timeline.
Furthermore, they pointed out that another federal judge in a related proceeding had previously expressed on the record concerns about the adequacy of the plaintiff's counsel. They argue this historical context completely validates their aggressive investigation into who was actually pulling the strings of the class action.
So to them, the subpoena was not harassment at all.
Right. To them, it was a mandatory exercise of due diligence to protect their client from a potentially illegitimate class representative.
So their position is presented at full strength, the challenge is pending, and the entire sanctions order could be completely vacated. But again, our goal isn't to decide if the subpoena in Patel was righteous advocacy or vexatious harassment. Our goal is to ask the structural question: why does the system predictably produce this exact dynamic? Why do highly capable professionals find themselves locked in these existential, reputation-destroying death matches over the procedural rules of engagement?
And to answer that, the briefing turns to the mathematics of human behavior. It introduces a game theory framework called the Nash disequilibrium.
Okay, game theory.
Yeah. To understand how this applies to litigation, we have to look at the foundational model of game theory, the prisoner's dilemma.
Everyone knows the classic setup, right?
Yeah.
Two criminals in separate interrogation rooms. The math dictates that you should always betray your partner to protect yourself, even though if you both just kept your mouths shut and cooperated, you'd both get a lighter sentence.
Exactly. But the classic prisoner's dilemma is a one-shot game. You play it once, you go to jail, and it's over. Litigation between major law firms like Davis Wright Tremaine and Dovell and Lunar is not a one-shot game. It is what political scientist Robert Axelrod studied in his famous 1984 book, The Evolution of Cooperation. It's an iterated game.
Meaning you play it multiple times.
You have to play against the same opponent over and over again, month after month, across multiple cases.
And Axelrod found that in an iterated game, cooperation actually can emerge, right? You don't just blindly betray each other forever. You use strategies like tit for tat.
Yeah.
I will cooperate with you today, but if you stab me in the back on this motion, I will retaliate on the next one until you learn to cooperate again. It's a way of training the opposing side to play by the rules.
Precisely. The shadow of the future forces cooperation. However, Axelrod mathematically proved that this cooperative equilibrium only survives if three strict environmental conditions are met. First, you need that repeated play. Second, you need clear signals, meaning both players must be able to unambiguously recognize whether the other side just cooperated or defected.
Okay, and the third?
And third, you need low noise. Accidents must be rare, and when they do happen, they must be easily recognizable as innocent accidents, not intentional attacks.
So if those are the required conditions for civility, how does the American litigation system score?
It fails the clear signals and low noise requirements catastrophically. The system is designed to be deafeningly noisy.
I really want to focus on this concept of noisy signals because it explains so much of the anger in the legal profession. Let's think of noise not as static on a radio, but like the fog of war in a military conflict. Or like how a text-based algorithm completely misinterprets sarcasm. The intent of the sender and the perception of the receiver are just entirely disconnected.
That's a great way to put it.
Because in litigation, attorneys operate under a strict ethical mandate called zealous advocacy. You must fight vigorously for your client. But the line between zealous advocacy and vexatious abuse is fundamentally subjective.
Let's apply that fog of war to the Patel subpoena. To Jacob Harper and his defense team, issuing that subpoena is the textbook definition of zealous advocacy. They have a judicial record suggesting issues with the plaintiff's counsel. They suspect former counsel might be improperly influencing the case. They view aggressive investigation as their ethical duty to protect GT's living foods. The signal they believe they are sending is, we are diligent, thorough defenders of our client.
But the signal gets completely distorted in the fog. To the lawyers receiving that subpoena, who maintain they have moved on and have absolutely nothing to do with the case anymore, that exact same piece of paper does not look like due diligence. It looks like a tactical missile designed specifically to burn their billable hours, drain their resources, and harass a non-party.
The signal is completely ambiguous. It is the exact same legal document, but the subjective realities of the sender and the receiver are irreconcilable. One side reads, doing my job, the other side reads, malicious attack. That discrepancy is the noise in the system.
And the Nash disequilibrium theory explains exactly what happens when a judge tries to use a weapon from the bizarre to fix this noisy environment.
Right. When a court steps into a low-noise environment, for example, if a lawyer was caught outright fabricating a piece of physical evidence or deliberately lying about a deadline a sanction works, it is universally understood by all parties as a legitimate punishment for a clear defection. The sanctioned lawyer might be angry, but they recognize they broke a hard rule.
But when a judge drops a heavy sanction in a high-noise environment, like a dispute over the scope of a subpoena or whether a meet and confer call was sufficiently collaborative, the psychology completely changes. The punished lawyers do not experience a moment of clarity. They don't look at the $100,000 fee award or the order to take ethics classes and think, the system is wide. I have seen the error of my ways.
Absolutely not. Their perception of reality remains intact. They view the sanction not as justice, but as an unprovoked defection by the opposing counsel who filed the motion, aided by a referee who fundamentally misread the play. And according to game theory, what is the mathematically rational response when you believe the other side has just launched an unprovoked defection against you?
You retaliate. You trigger the counterattack to reestablish deterrence.
This is the mechanism Jack Russo terms the grim trigger spiral. In a high-noise environment, the rational response to being sanctioned is never to apologize. The rational response is to immediately appeal the sanction, aggressively litigate the specific wording of the judge's order, and begin meticulously scouring the opposing counsel's behavior to find an excuse to file your own counter-sanctions motion. By attempting to enforce a blurry line with blunt punishment, the system actively generates escalation. It manufactures the exact satellite litigation it was designed to prevent.
Wow, so the grim trigger spiral explains why the ecosystem devolves into lawyers litigating each other. A noisy tactic is deployed. It's perceived as abuse. A sanctions motion is filed. The court punishes. The punished side perceives the punishment as an unprovoked attack and files appeals and counter-motions. And the underlying lawsuit is just abandoned while the lawyers fight a proxy war over their own reputations.
Yes. And the historical record of the 1983 Rule 11 wars perfectly validates this model. Third-party punishment in a noisy environment guarantees endless war, not civility.
Which really forces us to ask if the punishment mechanism just creates escalation. Who is actually absorbing the damage of this broken weapons bazaar? The briefing introduces a concept in Section 4 called the targeting inversion, and this completely changes how you view the financial stakes of these battles.
It reveals a profound disconnect between who the system thinks it is punishing and who actually bears the weight of the penalty. The briefing breaks down the anatomy of a sanction into 3 distinct orders of consequences: first order, second order, and third order.
Okay, so the first order consequences are what you read in the headlines. It's what the judge writes in the actual order, the monetary fine you have to pay, or the specific CLE classes you were ordered to attend.
And the paradox of the first order consequence is that for the institutions actually driving the litigation, the massive national law firms with hundreds of partners and their multi-billion-dollar corporate clients, the financial sanctions are functionally meaningless as a deterrent.
The briefing provides an incredible example of this involving Facebook. District Judge Vince Chabria in the InReef Facebook litigation imposed a massive $925,000 discovery sanction against Facebook and his powerhouse law firm, Gibson Dunn. Almost $1 million in fines for discovery misconduct.
To a normal human being or even a mid-sized business, $1 million fine is a catastrophic, potentially bankrupting event. But how did the judge himself contextualize that amount for a trillion-dollar tech giant and a global law firm?
How?
He explicitly wrote in his order that the $925,000 was almost certainly under-compensatory and dismissed it as mere loose change for the institutions involved.
Loose change. If the punishment is loose change, it cannot change behavior.
Exactly. The institution absorbs the fine as a...
And the judges know this. Judge Hickson in the Patel case explicitly quoted Judge Chabria's loose change line in his own order. He used it to justify why he wasn't just fining Davis Wright Tremaine, but was instead ordering the individual attorneys, Harper and Eli Myers, to physically go sit in ethics classes. He recognized that fining the institution would achieve nothing.
He recognized the impotence of the first-order consequence, yeah. But this is exactly where the targeting inversion becomes toxic, because of the second and third-order consequences. The massive firm pays the loose change without blinking. But who carries the burden of those downstream effects?
The individual human beings. The lawyers whose names are actually on the pleading.
Let's dissect the second-order consequences. These are the automatic, non-discretionary cascades triggered by the entry of a sanctions order. Take California, for example. Under Business and Professions Code, Section 6068, if an attorney is sanctioned $1,000 or more, albeit with some complex exceptions regarding discovery sanctions, they have an affirmative mandatory duty to self-report that sanction to the state bar.
Wait, really? You are legally required to raise your hand and flag yourself to the regulatory agency that controls your license to practice law.
That is just the beginning. The real damage occurs in what we can call disclosure gravity wells. The legal profession requires constant, sworn disclosures. Every time that sanctioned lawyer applies to be admitted pro hac vice in another state.
Which means seeking special permission to represent a client in a jurisdiction where they aren't fully licensed. Right. A process that requires rigorous character and fitness scrutiny.
Exactly. They must disclose the sanction. Every time they fill out a questionnaire for a judicial appointment or sign a declaration asking a federal judge to approve them as adequate counsel to represent a class of plaintiffs, they face the exact same question: have you ever been sanctioned by a court?
Oh, wait, let's go back to the Patel case. We noted that Harper and Illy Myers are aggressively challenging that order. What happens if they win? What if the appellate court looks at the record, agrees the judge relied on clearly erroneous facts, and completely vacates the sanction?
This introduces a concept borrowed from physics called reversal hysteresis. In physics, hysteresis means that the state of a system is dependent on its history, even after the forces acting on it have been removed. In the civility economy, it means the echo outlasts the order.
The permanent record.
Yes. Even if an appellate court completely vindicates those lawyers, declares their subpoena was perfectly appropriate, and mathematically erases the sanction from the docket, the permanent paper trail remains alive. When they fill out their firm's malpractice insurance renewal forms or those pro-hack vice applications, they will still likely be forced to check a box acknowledging the event. They will have to say, yes, I was sanctioned by a federal magistrate. But here is a 3-page addendum explaining how it was completely overturned on appeal. The asterisk is permanently affixed to their professional identity.
Oh, wow. So the appellate reversal unwinds the legal order, but it cannot unwind the reputational echo. The algorithm of the internet never forgets that initial headline,
which seamlessly transitions into the third-order consequences market and systemic adaptations. We are talking about severe reputational repricing. Opposing counsel in future cases will inevitably run a docket search, find that old sanctions order, and attach it as Exhibit A to their own briefs to argue a pattern of historical misconduct.
Yeah, that makes sense.
And sophisticated corporate clients might read the initial trade press articles in Law 360 and silently decide to hire a different attorney to avoid the perceived baggage. Malpractice insurance actuaries might adjust the firm's premiums upward.
This targeting inversion is devastating. The massive law firm which sets the aggressive billing expectations, dictates the combative culture, and demands scorched earth results just pays the loose change out of petty cash. Meanwhile, the individual attorney who executed the firm's strategy is branded with a radioactive permanent record that follows them for the rest of their natural life.
And that natural life in the profession is expanding significantly, which amplifies the penalty mathematically. The briefing incorporates demographic analysis from Jack Russo's broader work, specifically the 7 quotients, focusing on the concept of the 70-year work span.
This completely reframes the timeline of a career. Russo talks about the healthy 100 years shifting from science fiction to a plannable demographic reality. If an individual preserves their brain span, their cognitive health, and executive function, an attorney who gets licensed at age 25 could realistically remain active in the profession into their 90s.
They might transition from active trial work to serving as a senior status arbitrator, a mediator, or a strategic consultant, but their professional reputation remains their primary currency for 70 years. So if we apply the math of the 70-year work span to the targeting inversion, the risk calculus of incivility becomes terrifying.
Let's do the math on that. Imagine a junior partner at age 35. They decide to deploy a classic Rambo tactic in discovery. Maybe they schedule a critical deposition for 1:04 a.m. on a holiday weekend, or they completely stonewall a clearly legitimate document request to starve the plaintiff of resources. They do this to gain a tiny temporary tactical advantage in one single case.
By doing so, they are purchasing a reputational liability that they will have to service for the next 60 years. It is compounding negative reputational interest. Every time they step in front of a new judge who has read their disciplinary file, every time they try to negotiate a settlement with a new opposing counsel who doesn't trust them, that prior record acts as a friction multiplier.
That's a huge burden to carry.
It is. The California State Bar, for instance, explicitly treats any prior record of discipline as a mandatory aggravating factor in future proceedings. It is a weight that only grows heavier over time.
So the diagnosis of the system is exceptionally grim. We have an overarching mission statement in Rule 1 that is entirely toothless. We enforce it using a weapons bazaar of blunt instruments in a high-noise environment, which predictably triggers a grim trigger spiral of endless retaliatory satellite litigation. And when the dust settles, the punishment completely misses the institutions driving the behavior, while permanently scarring the individual attorneys who have to survive in the profession for 70 years.
It's a bleak picture.
If the system is this broken, how do we fix it? What is the way out of the bumper car arena?
The briefing dedicates its final section to this exact question, evaluating and ranking 15 different structural alternatives to the current sanctions regime, scoring them based on their expected efficacy and political feasibility.
Okay, let's analyze this matrix, starting with the mechanisms that rank at the absolute bottom, the tactics the system needs to abandon immediately.
Down near the bottom, at number 12, is court-ordered CLE remediation. This is highly relevant because this is precisely the remedy Magistrate Judge Hickson deployed against the defense lawyers in the Patel case.
See, it intuitively sounds like a reasonable compromise. You didn't understand the rules, so the judge is making you go back to school to take an ethics class. Why does the briefing rank it so poorly?
Well, it fails on two fronts. First, it is surprisingly vulnerable to constitutional due process challenges. The briefing cites a 2020 precedent, Hawkins v. Kroger, where a magistrate judge ordered very similar remedial training sanctions to punish discovery gamesmanship.
What happened there?
However, the district judge eventually overturned those sanctions, specifically ruling that the attorneys had not been provided adequate due process before being sentenced to forced education. Second, on a purely psychological level, there is zero empirical evidence suggesting that forcing an enraged defensive attorney to sit through a 2-hour PowerPoint presentation on civility alters their strategic behavior when they return to the trenches of high-stakes litigation. It is a performative punishment.
If performative education is bad, what is worse?
Ranking even lower at number 13 is the proposal for compelled public apologies. This involves forcing the offending attorney to draft a written apology, which is then archived in a publicly searchable judicial database.
A permanent digital wall of shame. I mean, I can see why people might suggest this. It bypasses the loose change problem because it attacks the lawyer's reputation directly rather than the firm's wallet.
It is arguably the most destructive proposal on the matrix, especially in a high-noise environment. First, legally, coercing speech from a citizen invites massive First Amendment challenges.
Right.
Second, from a psychological perspective, coerced apologies are entirely ineffective. The recipient completely discounts them as insincere, recognizing they were produced at gunpoint.
And it maximizes that reversal hysteresis effect we talked about.
Exactly. Creating a permanent, globally searchable archive of shame maximizes the permanent reputational damage. If the underlying finding of bad behavior is subjective and blurry, which we establish most discovery disputes are, the accused lawyer will view the compelled apology as an existential threat to their 70-year career.
They'll fight it tooth and nail.
They will fight the apology order to the death. They will appeal it to the highest possible court. It becomes the ultimate catalyst for the grim trigger spiral, guaranteeing years of retaliatory satellite litigation.
So if public shaming and forced ethics classes are the losers, what mechanisms actually work? What ranks at the top of the matrix?
The highest-ranked solutions represent a fundamental paradigm shift. They abandon the concept of after-the-fact punishment entirely and instead focus entirely on structure and signal clarification.
The number one ranked mechanism is active judicial case management, combined with pre-motion joint letter rules. Let's explain how a pre-motion joint letter actually changes the behavioral physical of a dispute.
Under the standard broken system, if lawyer A believes lawyer B is hiding documents, lawyer A might spend 50 billable hours drafting a massive vitriolic 25-page motion for sanctions, attaching hundreds of pages of exhibits.
Yeah, lots of billable hours.
Lawyer B receives this declaration of war and spends 50 billable hours drafting a furious 25-page opposition brief accusing lawyer A of harassment. The sunk cost fallacy kicks in. Both sides have billed tens of thousands of dollars, and they are now entrenched in total war.
But a joint letter rule short-circuits that entire process.
Exactly. A judge with a standing joint letter order prohibits the filing of any discovery motions. If a dispute arises, the attorneys must physically or virtually meet and confer. If they remain deadlocked, they are forbidden from filing separate briefs. Instead, they must collaboratively draft a single, strictly limited 5-page letter to the court.
Wow.
Lawyer A gets 2.5 pages to state their demand. Lawyer B gets 2.5 pages in the exact same document to state their objection.
It forces collaboration, even in the midst of total disagreement. You literally have to format the document together.
More importantly, it front-loads the intervention. The judge reads the 5-page letter, understands the contours of the dispute, schedules a 15-minute Zoom conference, and issues a ruling on the spot. They just say, produce these 3 categories of emails, skip the rest, get back to work.
That's incredibly efficient.
The judge instantly clarifies the noisy signal before the lawyers have spent 100 hours drafting sanctions motions. The ambiguity is removed without anyone needing to be punished.
You diffuse the bomb while it's still just a spark. The briefing also highly ranks the use of special masters and discovery referees.
This operates on the same principle of immediate signal clarification. In highly complex commercial or patent matters, the court appoints a neutral expert, often a retired judge or senior attorney, whose sole responsibility is to manage the discovery process in real time.
Oh, nice.
If a dispute arises during a deposition over whether a question is appropriate, they don't file a motion to be heard 3 months later. They call the special master on the phone, who rules instantly. It prevents the escalation loop from ever gaining momentum.
And this preference for structure over punishment isn't just theoretical. The briefing highlights a massive institutional choice made by the state of California regarding this exact philosophical divide.
It is a profound historical pivot. In 2021, the California Civility Task Force released a comprehensive report analyzing the breakdown of professional behavior. Their primary recommendation was to arm the regulators. They proposed amending the rules of professional conduct to make incivility an independently disciplinable offense.
They wanted to give the state bar the direct authority to suspend or disbar attorneys simply for being abusive jerks.
The ultimate weapon for the bizarre. Make being a jerk a regulatory crime.
But in September 2025, the California Supreme Court, which holds the ultimate authority over the rules, reviewed the proposal. They looked at the punishment model squarely in the face, recognized the high-noise environment, and explicitly declined to adopt the disciplinary amendments.
And what did the highest court in the largest state choose to do instead?
They rejected punishment and chose culture. Instead of a new disciplinary rule, they instituted an annual aspirational civility oath. Every single year, active attorneys must formally affirm their commitment to conduct themselves with dignity, courtesy, and integrity.
That's a huge shift.
Right. The Supreme Court made a clear institutional statement: you cannot punish your way to a civilized profession. You had to build structures and cultural norms that prevent the hostility from taking root in the first place.
So bringing this all back to the listener, if you are a founder about to sign a major term sheet or a business leader who realizes litigation is inevitable, what is the practical application of this deep dive? How do you protect your company from being dragged into a 35-month, money-burning bumper car rally?
Yeah. What's the takeaway here?
The primary takeaway is defensive engineering. You must internalize the fact that if you rely on the default court system and post hoc sanctions to protect you from an abusive opponent, you have already lost.
It's too late.
By the time your lawyers are drafting a sanctions motion, your resources are burning, your focus is shattered, and the merits of your actual business dispute have been entirely derailed.
You cannot wait for the system to save you. You have to engineer the environment before the conflict even starts.
Exactly. Choose your battlegrounds strategically. When drafting contracts, negotiate venue clauses that place potential disputes in jurisdictions with specialized business courts like the Delaware Court of Chancery or specific commercial divisions in state courts.
Why those specifically?
Because these venues are populated by repeat player judges who actively manage cases and enforce rigorous, low-noise cultural norms. And when litigation does inevitably spark, instruct your outside counsel to immediately negotiate aggressive case management protocols with the other side. Demand that they stipulate to pre-motion joint letter rules or agree to hire a standing discovery referee before the very first subpoena is ever drafted.
Build the guardrails yourself.
You must proactively construct a low-noise environment for your specific dispute because the default machinery of the civil system will simply hand everyone a bumper car and step back.
Control the environment before the environment controls you. That is incredibly actionable advice for anyone managing corporate risk. As we close out this deep dive, I want to leave you, the listener, with a final provocative thought that builds on this entire architectural breakdown. We've established that the current litigation system operates in a deafeningly noisy environment. We've seen that it structurally rewards those entities capable of enduring the highest thresholds of adversarial friction, astronomical costs, and reputational damage. The trillion-dollar institutions pay the loose change, the individual attorneys absorb the permanent scars to their 70-year careers, and the actual pursuit of a trial on the merits has virtually vanished to 0.4%.
It really has.
If all of that is true, what does that mean for the pursuit of truth in the justice system? If the system has devolved into a pure endurance contest of procedural attrition, is truth even the objective anymore? And furthermore, if human referees, our judges and magistrates, are simply too overloaded, too constrained by precedent, and too vulnerable to the subjective fog of war to clearly signal the boundaries of zealous advocacy without triggering endless retaliation, where does this inevitably lead?
That's the big question.
Will artificial intelligence eventually be forced to step in to save the system from itself? Are we heading toward a near future where a highly trained legal AI, acting as the ultimate emotionless, instantaneous referee in every single discovery dispute, is the only mathematically viable way to finally clarify the signals, eliminate the noise, and force human lawyers to cooperate? It is something to seriously ponder as you navigate your own high-stakes negotiations and consider the future of dispute resolution.
Definitely something to think about.
Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.